Good afternoon. I'm Councillor Diane Donaldson and I'll be chairing this hearing of Subcommittee B of the Licensing and Public Protection Committee of Birmingham City Council. Before we start, can you all please mute your microphones for the moment in order to improve the sound quality whilst I outline the procedure. Can you also please turn off your cameras with the exception of committee members unless you are the person speaking. This is to reduce bandwidth. Committee members will have their cameras switched on throughout the hearing. So both have their cameras switched on. Could everyone attending today's meeting please put their mobile phones on silent and ensure that they are situated in a room or environment which is free from distractions or any unnecessary noise emanating from radios, TVs, etc. Thank you for that. I'm speaking slowly and clearly so everyone can follow. It is vitally important, for what I hope are obvious reasons, that those attending the meeting and making representations are able to hear me and members of my subcommittee and officers. Any distractions brought to my attention could result in the meeting being suspended temporarily or to another date and time under the regulations for these types of meetings. I can also confirm this is a public meeting and is therefore being live streamed on the City Council's website in order that the general public can view it. I advise the meeting will be webcast for live or subsequent broadcast via the Council's meeting YouTube site, and that members of the press public may record and take photographs except where there are confidential or exempt items. Members are reminded they must declare all relevant pecuniary and non-pecuniary interests arising from any business to be discussed at this meeting. If a disposable pecuniary interest is declared, a member must not speak or take part in that agenda item. Any declarations will be recorded in the minutes of the meeting. Apologies were submitted on behalf of Councillor Mike Sharp and we have Councillor Leddy in attendance. Can I welcome you to this hearing for an application to vary the licence in respect... Sorry, we've got the wrong one here. Just bear with me a moment. In respect of Salem East African Restaurant, 136150 Soho Hill, Unit 3, Birmingham, B19 1AF. I'll begin with some introductions. My name is Councillor Diane Donaldson and I'm chairing this meeting of the Licensing Subcommittee. With me are other members of the subcommittee, Councillor Mike Leddy and Councillor Adam Higgs. Also present are the following officers: Licensing Officer Bipinda Nandra.
Afternoon, Chair.
Afternoon. Committee Manager Katie Townsend.
Good afternoon, Chair.
Good afternoon. Committee Lawyer Joanne Swampillai.
Good afternoon, Chair.
Good afternoon. Could I ask all the parties to identify themselves, please? Firstly, the applicant, West Midlands Police.
Thank you, Chair. Mark Swallow, West Midlands Police.
Good afternoon, Mark. And next, those making representations, Martin Key, Environmental Health.
Afternoon, Chair. Thank you. Martin Key, Environmental Health, Birmingham City Council.
I can't hear you very well, Mark. Can others hear? Martin, sorry.
I think my microphone might have just moved, so I just pushed it back. Is that better?
That's better, thank you. And Christine McCulloch, Licensing enforcement.
Good afternoon, Chair.
Good afternoon. And finally, the licence holder, if present, his representative, he's Thomas Solicitor.
Good afternoon, Chair. So it's Heath Thomas from Harrison Park Rickaby's, and then with me immediately to my right is Mr. Hadju. He's the premises licence holder and designated premises supervisor, and then Mr. Tesfaye, who's a co-owner of the business, and he's referred to in the paperwork.
Thank you. Good afternoon to you all. Could I ask if any persons making representation wishes to withdraw their representations at this stage of the hearing?
Mark Swallow from West Midlands Police. No, Chair.
Martin Key, Environmental Health. No, Chair.
Christina McCulloch, Licensing Enforcement. No, Chair.
Thank you. Thank you all. I will assume that all parties have read and understood the Licensing Committee's procedural rule set out with the notice of today's hearing. Please note that given the nature of today's proceedings, I may, at my discretion, amend the procedural rules to reflect the fact that this meeting is taking place online, but wish to assure you all that any such amendments will not impact on the parties' right to a fair hearing. We'll be using the chat function in Microsoft Teams to communicate. One of the icons on your toolbar is a speech bubble. Click the speech bubble to go into chat if you do not have access to the chat function for any reason. Please use the raise a hand function to indicate you wish to speak. That button is usually fourth from the right on the toolbar. You can also, of course, indicate verbally that you wish to speak at the appropriate time.
That's everyone, Chair.
Thank you, Katie. Please keep this chat column open for the entire duration of the meeting in order that everyone can follow the messages being posted in the chat. If any participant has dialed in on an audio telephone rather than Microsoft Teams, please speak now. To confirm that you can hear and be heard. I take it that nobody is dialing in today. With the exception of subcommittee members, please keep your camera off unless you are the person speaking. If there are problems with bandwidth which cause difficulties with the sound, I may, in my discretion, ask everyone to turn their cameras off in order that the meeting can proceed with everyone able to hear and be heard. Does anyone wish to make any preliminary points at this at this stage? If so, please indicate that you wish to raise a point by typing speak into the chat function or using the raise a hand function now. Thank you. I'll now briefly outline the procedure which will be following at today's hearing. Firstly, the Licence Officer, Bapinda Nandra, will present the report. Then the applicant, West Midlands Police, will be asked to present their case. We're asking if it could be kept to approximately 20 minutes. Then those making representations will be invited to make their case. Again, approximately 20 minutes will be allowed for this part of the hearing. Finally, the licence holder will be invited to make their case. Again, approximately 20 minutes will be allowed for this part of the hearing. Can I ask all parties to speak as slowly and as clearly as they possibly can, because the officers are taking notes by hand for the minutes, and the meeting is also being live streamed on the City Council's website. If at any time it's somebody else's turn to speak, please mute your microphones and use the chat function to communicate if necessary. Please note that members of the subcommittee will be able to ask questions at any stage, but will try to do so at the conclusion of each presentation. Cross-examination by the applicant and those making representations will not be permitted unless the members consider it appropriate. Where questions are raised by members of the subcommittee or those present, they must signify this using the chat facility set out on the right-hand side of the screen you're viewing this meeting on. The meeting manager will alert me if I do not notice messages in the chat. I will determine verbally or in writing on the chat facility the order in which questions are dealt with. So at any point in the meeting, if you wish to speak, please type the word "speak" into the chat function, and the meeting manager will ensure that we come to you at the appropriate moment. If at any point you cannot hear or are having problems with your internet connection, please use the chat facility to alert the meeting manager. The chair will then ask the person speaking to repeat what they just said. It is therefore important that you use the chat function as soon as you are unable to hear the person speaking. It may well be that the problem is caused by people still having their microphones or cameras on, which creates interference. So I will remind everyone to please mute their microphones and turn off your cameras when you're not the person speaking. Could I point out that occasionally it might be necessary for the subcommittee to take legal advice? At my discretion, I may ask all parties to wait in this meeting whilst members and the relevant officers withdraw to take legal advice using a separate meeting within Microsoft Teams. We will then return to the meeting and continue. Please note that if any time the live stream being broadcast on the City Council's website fails, I will ask you all to mute your microphones and cameras and to stop speaking until the live stream is restored. If at any time this meeting goes into private session, the meeting manager will pause the live stream. Once the private part of this meeting is over, I will ask the meeting manager to confirm that the live stream has resumed before we continue. At the conclusion of the hearing, I will invite all parties to make a brief closing submission. Can I stress that no decision will be taken until all the evidence has been heard? At the decision-making stage, the members and their relevant officers will withdraw from the meeting in order to determine the decision. They will go into a separate Microsoft Teams meeting. In the event that members need to clarify any point, you will be telephoned by the meeting manager. The members will then make their decision. You'll be notified of the decision of the subcommittee within the statutory time limits. I hope that's reasonably straightforward. So with that, can I ask the licensing officer, Bapinda Nandra, to present the report, please, as slowly and as clearly as possible. Thank you.
Thank you, Chair. West Midlands Police applied on the 8th of July 2021 for a review of the premises licence under Section 51 of the Licensing Act 2003 for Sealam East African Restaurant 136 to 150 Soho Hill, Unit 3, Birmingham, B19 1AF. The purpose of the report is to consider an application to review a premises licence. A representation has been received from Environmental Health as a responsible authority, which is attached at Appendix 1. A representation has been received from Birmingham City Council Licensing Enforcement as a responsible authority, which is attached at Appendix 2. The review application is attached at Appendix 3. The premises license is attached at Appendix 4, and the site location plans are attached at Appendix 5. When carrying out its licensing functions, a licensing authority must have regard to Birmingham City Council's Statement of Licensing Policy and the guidance issued by the Secretary of State under Section 182 of the Licensing Act 2003. The licensing authority is also required to take such steps as it considers appropriate for the promotion of the licensing objectives. The options available to the subcommittee today are to modify the conditions of license, to exclude a licensable activity from the scope of the license, to remove the designated premises supervisor, suspend the license for a period not exceeding 3 months, revoke the license, or to take no action. Where the authority takes a step to modify conditions or exclude a licensable activity, it may provide that the modification or exclusion is to have effect for only such period not exceeding 3 months or as it may specify. Thank you, Chair.
Thank you, Happinder. Would the applicant, West Midlands Police, like to make their representation now?
Thank you, Chair. Ceylon East African Restaurant is a restaurant located at Unit 3, 136 to 150 Soho Hill in Handsworth, Birmingham. The premises licence holder and designated premises supervisor is Tekelbran Hadju. Premises is licensed to sell alcohol for consumption on the premises between 12 midday and 23:30 hours each day, and has late night refreshment till 23:30 hours. On Tuesday, the 19th of December 2017, Licensing Subcommittee B, following the advance agreement of West Midlands Police and Environmental Health, imposed a number of conditions on the premises. These included the premises shall install and maintain a comprehensive CCTV system. The CCTV system shall continue to record whilst the premises is open for licensable activities and during all times when customers remain on the premises. All recordings shall be stored for a minimum of period of 31 days with date and time stamping. Viewing of recordings shall be made available immediately upon the request of police or authorised officers throughout the entire 31-day period. On the 29th of March 2021, the UK government enacted the legislation, the Health Protection Coronavirus Restrictions Steps England Regulations 2021, which stated in Schedule 2, Part 2, 13.2g, a premises must not for payment or otherwise provide 1, a water pipe to be used for the consumption of tobacco or any other substance on the premises, or 2, a device to be used for the recreational inhalation of nicotine or any other substance on the premises. This is also controlled by the Smoking Act of 2007, which allows for consumption in the open air or in a shelter where in excess of 50% of the wall space is open to the open air. On Friday, the 4th of June 2021, Mr. Dan Edwards from Birmingham Environmental Health visited the premises and found people consuming shisha in the premises. As a result, the premises were issued with a prohibition notice, which detailed that shisha could not be consumed on the premises. That is effectively a warning. On Saturday, the 5th of June 2021, Mr. Edwards returned to the premises and again found people inside consuming shisha. As a result of this, a fixed penalty notice was issued to the premises to the value of £1,000. On Friday, the 25th of June 2021, Inspector Mark Poulter and myself visited the premises in the evening. The door to the street was locked, and despite repeated knocking and being identified as police, it took the designated premises supervisor some 5 minutes to open the door. Inside, at the rear of the premises, there were a number of customers. There was a cloud of smoke and the smell of shisha. Mouthpieces from the pipes were discarded on the floor, and there was also burnt ash there. In the rear rooms of the premises, there were burning shisha coals in shisha pipes. The fire door was also wedged closed with packages. The DPS, Mr. Hadju, was spoken to and initially denied the consumption of shisha on the premises. On further questioning, it was found there were sales in the register of shisha. Mr. Hadju was also asked to operate the CCTV so that the premises could be viewed. This, he stated, could not be done as the CCTV system had been broken for over a week and he couldn't get it repaired until later. Mr. Hadju admitted that people had been consuming shisha just outside the doorway of the premises and later admitted that as a result of the rain, he had allowed the people consuming shisha to come inside the premises to carry on. Mr. Hadju was issued with the fixed penalty notices for £2,000 in relation for this. He was also reported for carrying out licensable activity in breach of the conditions of his licence, in that he did not have working CCTV, and he was advised that if he carried out further activity, this would be separate offences. As a result of searching the premises, in the billiard room were found 7 persons playing a snooker table-based game. All were standing and were not wearing masks. They were not from 2 family groups and were issued with £200 fixed penalty notices. The following day, Saturday the 26th of June 2021, PC Kiran Patel visited the premises. PC Patel again found the door locked and it took some time for him to be allowed access to the premises. He found people drinking alcohol, which was sold by the premises. The CCTV was still not working and patrons had again consumed shisha. The designated premises supervisor was again issued with a fixed penalty notice in relation to this time to the value of £4,000. He told PC Patel that he needed to continue to trade despite the fines being issued. In all, the premises has been visited on 4 separate occasions. On each occasion, the premises have been in breach of the coronavirus regulations that were in place at the time and the Smoking Act. On 2 of the occasions, the premises also did not have working CCTV, even though it was a condition of their licence to do so when carrying out licensable activity or persons being present on the premises. From this, it is my opinion that the premises routinely breach the law and their primary motivating factor is profit. This has put profit above public safety. This has been the case even after the matters have been pointed out to them. They've ignored the advice and carried on with the breaches. I therefore have no confidence that this premises will promote the licensing objectives and believe that as the premises licence holder and the designated supervisor are the same person, that the revocation of the licence and removal of the designated premises supervisor is the only course of action that I can ask for. Thank you, Chair.
Thank you, Mr. Swallow. Is that all the submissions the various representatives of the applicant wish to make?
Yes, Chair.
Thank you. Are there any questions from members?
No questions, thank you, Chair.
No questions, Chair.
Thank you. Can those making representations present their case now, please? Environmental Health Officer Martin Key.
Thank you, Chair. I'll try and be as brief as I can. Premises is located on a busy arterial road in a mixed-use area. It's part of a building that's previously been used for car repairs and a tyre business. There is residential use opposite and behind it, and it is a poor building in terms of overall construction for noise attenuation. There has been a history with our service on this premises. 2017, we had a number of temporary events that resulted in complaints due to noise and disorder. As a result of that, planning application was submitted, and as part of the controls, we restricted the hours of use and put a number of operational controls as well under the planning. Planning applications you've heard from the police that came forward previously, and in December 2017, we came to an agreement with the applicant, again, largely around hours of use and the range of activities to be carried out. And although that came in front of the committee, we'd already agreed to withdraw our representation. And subsequent to that, we've objected to a number of TENs where the applicant has sought to extend the operating hours due to the concerns over nuisance. The evidence that's been provided to you raises a number of key issues. The first is the premises does not comply with the Health Act. This legislation, so-called the smoking ban, came in 2006, 2007 in full implementation, and basically prevents the use of any tobacco or similar material inside an enclosed area. And you've heard from the police evidence that on a number of occasions visits have been made when there was smoking of shisha inside the premises, which would be in breach of the Health Act. Similarly, you've heard about the number of people that were present playing billiards with no social distancing and no masks. Just to clarify my evidence, there is an error in my original submission to do with the steps, and I think also maybe I just need to amend what the police evidence was. When these offences occurred, we were in step 3 of the coronavirus regulations, which actually is schedule 3 of the regulations. What they required at the time was that only food and drink could be supplied to people who were seated. It didn't require that to be outside, but similarly provided that it was a restricted business and a restricted operation for the use of water pipes and similar devices. And that was due to the high transmission risk for COVID as part of that operation. So the use of the shisha, which you've heard again, happened on a number of occasions, was specifically prohibited by the regulations due to the concerns about transmission. There was no ventilation to the building, hence the Health Act was in breach. Number of customers with no masks, no social distancing, and you've also heard about doors being shut and coals from the shisha being present, which raised concerns about fire hazards. We've worked very closely as a service with our colleagues in police and other partners to try and manage the COVID outbreak or pandemic, largely through education as a first step, and then secondary through enforcement where necessary. The issues here were clearly in breach of a number of primary provisions in terms of coronavirus regulations and guidance, Health Act, failure to follow the controls put in place to control the spread of coronavirus. And just to put it into context, the primary mechanism that this virus spreads is by social contact. It thrives on people being close together. We have now had over 6.7 million people in the UK contract coronavirus. In England, over 132,000 deaths. Birmingham has been quite badly affected. It has very low relative immunisation rates, and we've had approaching 3,000 deaths in Birmingham, and again over 145,000 cases. So these regulations were in place to control the spread of a significant pandemic that's impacted everybody's operating businesses and their lives for the past 2 years nearly, and this applicant was clearly in breach of that. And on that basis, we would fully support the police submission and their recommendation to revoke the premises licence in this case. Thank you very much.
Move on to Christine McCullough.
Good afternoon. Licensing enforcement. I've had numerous dealings with this premises since 2017, even before the premises licence was issued. we've only been dealing with Mr. Hadgo since November 2018, after the licence was issued. Previous to that, we were dealing with Mr. Tesfaye. Before the licence was issued, we had made numerous visits, which did result in a formal caution being issued to Mr. Tesfaye for unauthorised licensable activity and smoking on the premises. These offences for the caution were on the 25th of December 2016 and the 22nd of June 2017. So just to reiterate, that was a caution. During November 2018, we received information alleging that unauthorised licensable activity was taking place and that smoking shisha was also taking place on the premises. On this occasion, an inspection was carried out to ensure that the licence was acting within its licence conditions. However, a number of breaches were identified on this visit. The premises summary was not displayed. The full premises licence could not be produced, and Mr. Hadgo, who was the licence holder, and the DPS could not produce his personal licence. Mr. Hadgo was advised that these offences may cause an offence and he could be prosecuted for them. Whilst the officers were there, they also noticed that people were sitting at tables smoking shisha. So this is going back to November 2018. A notice was issued, which is attached in the bundle, advising of the breaches. On 6th of December, again, licensing enforcement officers visited the premises. Yet again, it was noticed that there were people inside the premises smoking shisha. Mr. Hadgo was told that he had been advised previously that this could not happen, but he did say that he had received a visit from another council employee and he'd been told that he could have shisha inside the premises if there was an extractor fan fitted. A further notice was issued to the premises advising of the breaches. When the officers returned to the office, the inquiries were made, and it was found that Mr. Hadgo had in fact had an email telling him by Environmental Health that he could not have shisha inside the premises. Licensing enforcement sent a further email to Mr. Hadgo advising him of this and that it must cease immediately. On the 16th of January 2019, Mr. Hadgo was formally cautioned in accordance with the Police and Criminal Evidence Act for the alleged breaches that had taken place. 6 months later, on the 13th of June, a further visit was made to the premises, and again, identical breaches were identified. It must be taken into account that at this point, Mr. Hadgo had been formally interviewed. He was aware of the implications and that a report was pending. A notice was again issued to the premises advising of the breaches, and he was told that a report would be submitted imminently. On the 10th of December 2020, Mr. Hadgo entered a guilty plea to carrying out licensable activities at a court hearing at Birmingham Magistrates Court. He was subsequently fined £300 for the offence. So this is 10th of December 2020. Mr. Hadgo does seem to have a blatant disregard for the law. Licensing enforcement officers have been out on so many occasions and have really tried to work with him, but he was just not taking the simple steps that were required to be within the law. I would fully support the representations that have been submitted by West Midlands Police and by Environmental Health. Thank you.
Thank you, Christine. Is that all the submissions the representatives wish to make on behalf of the licence holder?
Yes.
Thank you. Are there any questions from members?
No, Chair.
No, thank you, Chair.
Thank you. Can the licence holder representative make their case now, please? Heath Thomas.
Sorry, delay in trying to get the technology to work. My end, apologies for that. Chair, it'll come as no surprise that my submissions to you and your colleagues this afternoon are not going to be to revoke the licence, but to consider some other means of addressing some of the behaviour that you've heard from my client. I wish to obviously address you. What I can say, Mr. Hadju is the licence holder, Mr. Tesfaye, as I've already introduced him to you, is a part owner of the business. For them, English is not their first language. They're both from Eritrea, and English is a second language. And when it comes to sometimes interpretation of what have been quite difficult COVID health protection regulations, which we've had so many iterations of these as time has gone on, it's not surprising that some individuals may have fallen foul. But my client wants me to address you, and then they can confirm that what I say is correct as far as their instructions. But a couple of points first, if I may. We just heard from Christina McCulloch from Licensing Enforcement, with a submission to you that these are a premises licence holder who is just simply unable to comply with the premises licence that he holds. And I fundamentally disagree with that. You've heard about matters that go back as far as 2016. My client was dealt with for those matters, received a caution, and each and every time he's gone on to address the behaviour that led to their engagement at the time. And from the evidence that's presented to you, the evidence in which there is no challenge, between June 2019 and June 2021, we have no concerns expressed about the operation of the premises. And it's clearly indicative that this is a premises licence holder who has been able to promote the licensing objectives and has been able to comply with the health protection regulations at their highest during that time as well. And it's only when we're having some relaxation of those that my clients have fallen into some difficulty. And this breach is here. I disagree that this is about a breach of the Health Act 2006. The application that's been put before you is very much one that's about the health protection regulations in relation to shisha, and a condition of a license that talks about CCTV to operate. I haven't advised my clients in respect to the Health Act 2006, but they have had separate advice and dialogue with the environmental health and those officers that deal with the Health Act 2006. But fundamentally, I would be saying to you that you cannot, on the basis of that submission, accept that this is somebody who cannot comply. And from that period of time, which, as I say, cannot be challenged, it's clear that they've demonstrated for a 2-year period of no concerns or challenges to them. And even when I hear Martin Key speak, who equally talks about matters that go back to 2010, and he spoke about matters of noise nuisance. Public nuisance is not a matter that's before you. Sorry, Chair. Are you happy for me to carry on? Sorry, you disappeared from my screen for a moment.
Yeah, that's fine. Please carry on.
So Martin Key talks about 2017 and matters of temporary event notices and public nuisance. The review today isn't about public nuisance, but the evidence from that is that that's an occasion when the premises licence holder worked with the authorities to address a concern that had arisen with agreement and stopped doing the activity that was given rise to a complaint, just withdrew it and stopped doing that activity. So there are individuals who've sought to improve their business and to comply, not to willfully disregard any laws or rules that happen to be in place. And again, so that evidence is in terms of both Martin Key and Christine McCulloch as to how I would submit this is a premises license holder that actually, is seeking to do his best, but openly will admit to you and to me that he's got some degree of failing here, which I want to then go on to discuss in more detail. So the reality is that what we're looking at is the breach of the health protection regulations on the 4th and the 5th of June and the 25th and 26th of June 2021. In respect of those matters, what my client tells me that on the 4th of June, Mr. Tesfaye, who sits to my far right, was the person managing the premises. As I said to you, he's a part owner. And on that evening, he accepts that unwittingly for him, he permitted somebody to smoke by the premises, so it's within the confines of the premises, with the shutters open, and that was in breach of the then health protection regulations. And he accepted that, and he was given his fixed penalty notice for dealing with that. The following day, he wasn't at work. Mr. Hadju was present, and he was wholly unaware of what had happened the previous evening, unaware of the visit that had taken place, unaware of the advice that was given. And then he openly admits that he allowed a person to smoke what would otherwise be in the confines of the premises, but with the shutters open. And again, he accepts that wasn't a deliberate breach by him, but finding the difficulty to meander his way through the regulations at that time and to understand what was permitted and what wasn't. Because if you remember, we were all back allowed in licensed premises at that time. And my clients were looking around at what their competitors were doing, and they understood equally their competitors were doing the same. That's not to say that they weren't wrong. They openly admit on the 4th and 5th, in hindsight, now that they've had the benefit of some advice and they've seen the information produced by the officers, they admit that they got things wrong on the 4th and 5th. But moving forward from that time to the 25th and the 26th of June, they do not accept that they permitted smoking in their premises. I'll come on to the CCTV aspect separately, and I'll just try and deal with the health protection regulations in the first instance. My clients do not accept that they permitted smoking inside their premises on the 25th of June. They accept that they sold shisha for consumption off their premises. And in fact, smoking had taken place in the external area in the car park, which isn't part of their premises. And what my instructions are that it then came to rain. Those individuals ceased using the shisha pipe. My client's instructions are that he brought the shisha in through the building to where the shisha pipe room is inside. Nobody was permitted to smoke inside at that time. He carried it in and extinguished the coals in the shisha pipe room. Now, in carrying it in, he openly accepts that may give rise to a perception that smoking would have been permitted because there would be a smell that lingers, but it wasn't. No smoking took place. And there is no evidence in any of the witness statements that I have read of smoking actually taking place inside, but rather an assumption that smoking is taking place inside because there's a smell of shisha or there's a smell of smoke. And my client says that is not the case. And his instructions to me are very much, as I say, he brought that item in and didn't permit smoking inside. Now, over and above that, this is a premises that provides food which is of East African origin or East African cultural food. Now, that food, in order to be kept hot, is placed in something which resembles a vase, and on top of the vase is like a bowl in which the food would sit, And beneath that is a receptacle in which you place a hot coal. So it's a little bit like those restaurants where we either have a paraffin or a candle heater that keeps it hot. Here, culturally, it's a coal, and that is placed under the food dish. That equally gives off a smell, and which can then confuse and give the wrong perception that smoking has been permitted in the premises. And those are the instructions from my client in terms of that. But certainly what he says is he did not allow customers to smoke in the premises from the 25th of June in the knowledge that he was not enabled to do so. The police attended his premises that evening towards the end of the evening, and my clients were in the process of closing their premises. They'd had a problem with rainfall coming into the premises from outside, causing flooding internally, and so he had closed his door to prevent no more access to customers coming in, waiting for his customers to finish, and there were only a limited number of people there, and hence a delay then in getting to the door for the officers to gain entry. Looking at the following day as well, the 26th of June, what my client said in respect to the 26th of June is very similar, that again, no smoking was permitted inside his premises. There were approximately 8 people in the premises that evening when the officer arrived. It was closing time. All licensable activity had ceased. People were drinking up and people had finished their food. The door to his premises was closed because we were closed to the members of the public, and it was time now for them to leave, and it was closing time. And again, my client says in similar instructions in terms of there was no smoking going on in his premises. And as I say, I could see no evidence of that. And his explanation for how that perception might arise is exactly the same as it would be for the previous evening. But what he says on those dates, he hasn't breached the health protection regulations. What the officers say is that when they turn up on the 25th of June, they ask to see the CCTV footage, and the CCTV footage cannot be played. My client openly accepts that, and he's given his explanation to the officer. He has CCTV installed in the premises. It's correct to say that this is CCTV where West Midlands Police have had the benefit of viewing it on previous occasions. I believe, in fact, the 5th of June 2021 was one of those such occasions when Mark Swallow attended the premises to view CCTV from an incident which took place at another premises in the hope that my client's CCTV would capture what might have been going on in the street outside. And the officer was able to view CCTV in the premises, wholly unrelated to Salem East African Restaurant. But it demonstrated that CCTV was operational in the premises, was able to be played and replayed to the police upon request. But at the 25th of June, my clients, they've experienced problems with the CCTV. They'd recorded that problem in their incident record book, as they're required to by condition of their license. They contacted the CCTV provider and explained that they had a problem. The screens were not showing inside. And they were told that they had what they believed to be an internal connection problem. And the CCTV company would have to send an engineer out to come and repair that. At a time when the CCTV company is equally facing problems with its own staff doing face-to-face meetings and appointments. Look at what we're doing today. We're doing remote hearing for these very same reasons. This wasn't something that could be fixed remotely. It needed face-to-face. My clients had to wait for a week in order to have an engineer come out and then repair what was a connection problem. But the evidence isn't that these are somebody who's been non-compliant throughout. It's the evidence of an operator who has experienced a technical problem, who has then sought to address it. Should that operator, as a consequence of these things taken together, have their license revoked, or is there some other measure that the committee ought to consider imposing? And I would be submitting it's that latter thing that we ought to be consider for my clients today. So in terms of the CCTV, all of that has been repaired. It is working. Now, when we come to a review hearing, it's a little bit like an appeal. All evidence up until the date of today's hearing can be presented to the committee. And my clients have instructed me that on the 27th of August, Environmental Health visited the premises. It wasn't Martin Key, but it was one of his colleagues. Visited the premises, carried out their inspection, raised no comments or concerns with my clients about the operation of their premises, which only suggests to me that is because on their visit of the 27th of August, these are premises that were compliant. And we're also looking now at dates that are in June. So we're looking at dates that are 2 months ago and more, almost 3 months ago to the start of June. And I've got no fresh evidence that's brought before the committee that demonstrates that this is an operator that is failing to comply with their obligations either under the license itself or under the health protection regulations. And I would be submitting to you that actually they are compliant. And whilst they openly accept 2 non-compliance on the 4th and 5th of May and CCTV, which was beyond their control, nothing in their premises license says if your CCTV isn't working, then you must cease to provide licensable activity. I've given them advice in terms of what they should and shouldn't be doing, and they'd be aware of anything for the future. But in terms of what should we be doing here as an outcome, then what you've been asked to do by Environmental Health and Licensing Enforcement is to look at historical issues which are now woefully out of date in circumstances where there's been periods of demonstrated compliance. You're being asked to revoke the license. And in terms of West Midlands Police request, well, my submissions are that revocation would be a disproportionate response to what is at hand here in terms of this licensed premises. And perhaps a different measure would be in place, and whether or not the committee ought to consider a period of suspension of the license, which would send an appropriate message to the operator and to any other operators for that matter for non-compliance. But also it's a proportionate response perhaps to what it is that we are discussing this afternoon. Can I just ask my clients, please, if I may, if there's anything that I've omitted to say on their behalf, and then just respond? I'm just going to put myself on mute while I just ask that question. I'm grateful for that. Clearly, you would have seen me, but not heard me. And what Mr. Hadju is saying to me that in terms of the historic matters, which were around the complaints about noise nuisance, and that was around the Christmas time when they were hoping to put on entertainment, they've addressed all of that and removed it. It's not a feature of their operation going forward. And only finally that this is very much a community premises for the East African community around that part of the city. And of course, it's something that they would be able to want to carry that on. Without a license, they would still be able to operate, albeit only to 2,300 hours. and one would always say it's best to have greater control with a premises licence than to have an absence of control without it. But I've got no further submissions on behalf of my clients. Thank you, Chair.
Thank you, Mr. Thomas. Are there any questions from members?
No questions, thank you, Chair.
Yes, Chair.
Yes, Councillor Levy.
This is for Mr. Thomas and his clients. It seems to me that there's been a total disregard of the law regarding smoking of shisha indoors, resulting in fines in the magistrates' court, and obviously following the opening of the hospitality, where police and council officers have issued a total of £7,000 of fixed fines to the premises. And then in addition to that, for smoking of shisha, and then in addition to that, a further £1,400 on customers for, again, disregarding the COVID-19 regulations imposed at the time. What confidence can I have as a member of this licensing subcommittee that the premises licence holder and the DPS will comply with the laws and the conditions imposed by this subcommittee or any future subcommittee of licensing?
Thank you very much for that, Councillor Leddy. What I would say is, in part, we can see a 2-year period of compliance from June 2019 to June 2021, which is indicative of an ability to comply and learn from those lessons that were going on previously. In terms of the Health Act 2006 and smoking inside premises, it's fair to say that, and you know, experienced members of the committee will be aware that there are some consultants out there who don't fully understand the interpretation of that type of legislation, and very misleading information can be given to operators to follow. I think my client has now had the benefit of good advice in terms of that. And if you had concerns about visibility moving forward, then I propose a middle ground in a way. Consider a period of suspension of the licence with a condition that the premises licence holder resit or retake the award for personal licence holders to remind him of what his obligations are under the Act. And that would serve as an update that can be, you know, shown to the licensing department as well within any period of suspension. So it's a bit of education, and equally the stick to beat him with, for want of a better word, and the knowledge that if he were unable or unwilling to comply in the future, then a revocation of his licence would be the only decision that a committee would make following on from that in the future.
If I may, Chair, we've heard from one of the council officers, Ms McCulloch, and her comment was there has been a blatant disregard for the licensing conditions. Now, for us to hear such a comment does send alarm bells ringing. How many chances does the committee give to the premises licence holder and the DPS in regards to getting them to comply with conditions?
Well, in terms of that comment was made in terms of evidence that went as back as June 2019, which brings me on to this point about, you know, the 2 years of compliance, and also the visit to the premises last Friday by Environmental Health, where we have no concerns or comments that are raised. In terms of this, there was a voluntary change to a premises historically. I don't believe, and I'll be corrected if I'm wrong, that wasn't a review of a licence. We're asking for this This one chance, Councillor Leddy, where my client could demonstrate that with an appropriate and proportionate measure, as I pose to you as a suspension, with some added measures to follow.
Whilst I accept what you say, Mr. Thomas, in June we had 4 visits, and in June that when the total of £7,000 worth of fines were issued to the premises licence holder and the DPS combined. Is that correct?
No, that's not correct.
We had only 1,005. So when he was visiting the fields, he just gave us 1,005 paper in our hand in front of Mark Swallen. So after that, they visit on the 26 and 25 and 25th. After that, they don't give us any letter, anything. Just after 1 week, Birmingham City Council, they came and put on the door outside, your license is going to be reviewed.
Did you hear that, sir?
Well, I heard some of it, yeah. I mean, are we saying that the £1,000 fine issued by, was it Mr. Edwards? And then we had a £2,000 fine issued by Inspector Poulter, and then a further fine issued by I think it's PC Patel, when they visited on the 26th. So that totals up to £7,000 worth of fines, does it not?
So my instructions, Councillor Leddy, are that there's only one fixed penalty notice that has been handed to my clients for £1,000. And that was on the 5th of June. They have not been handed these other fixed penalty notices. I don't see them in the bundle. I've seen reference to them, but my instructions, as you hear, are that one fixed penalty notice.
Okay, well, perhaps Mr. Swallow can clarify things when he's summing up. Thank you very much. Thank you, Chair.
Thank you, Councillor Levy. Thank you, Mr. Thomas. Now, those making representations wish to make a closing submission. Licensing enforcement, Christine McCulloch.
Yes, Chair. I appreciate Mr. Thomas's comments that the matters I've raised today are dealt with. I bring the matters before you to highlight what I consider to be a pattern of non-compliance after advice is being given. We did make numerous visits to the premises for identical breaches, and even after a caution being issued to one of the partners when Mr. Hagdu was present and repeatedly telling them that legal proceedings would be instigated, they still failed to comply with simple requests. It does tantamount to a total disregard for the law, and considering the history of the premises and the flagrant disregard for complying with legislation, licensing enforcement does not have any confidence that the licence holder or the DPS is capable of promoting the licensing objectives, in particular the prevention of crime and disorder and public safety. Therefore, licensing enforcement would ask that this premises licence be revoked and that the DPS be removed. Thank you.
Thank you. I'll move on to Environmental Health Officer Martin Key.
Thank you, Chair. You've been asked to consider that the premises have been compliant for 2 years, when, of course, a big chunk of that, 12 months of that, they've been closed down due to the coronavirus lockdown. Also, just to go back to my Health Act point, the Health Act is very clear. It stops people smoking inside a substantially enclosed building. That's a building with a roof and with less than 50% of the side open. This premises meets that definition, and therefore any smoking of shisha inside the premises would be a breach of the Health Act. The concerns that have been expressed by ourselves and licensing enforcement historically, and the evidence the police have supplied, and the explanation that you've been given that the rain came through the roof, which is why there was people inside the building with shisha on the 25th and 26th, I think will have to be balanced against the history that this premises has. In my view, the operator's shown a cynical disregard for the Licensing Health Act and coronavirus regulations, as carried on and operated, even though they knew full well that this was in breach of the coronavirus regulations, which poses public safety and public health issues. and have sought to make financial gain from operating in breach of this, even though other companies and other businesses were forced to close down because of these controls. My view is that this shows a cynical disregard of the regulations, a history of non-compliance, and we would therefore support the original submission by the police that the premises licence should be revoked and the DPS removed, significantly on the grounds of public safety in our view. Thank you very much.
Thank you, Mr. Chair. Next applicant, West Midlands Police.
Yeah, thank you, Chair. Firstly, I'll deal with the issue that was brought up in relation to the fixed penalty notices. I can say that on the 25th and 26th, fixed penalty notices were issued to Mr. Hadju. Secondly, I'll say in relation to the issue that the premises licence holder has brought up in relation to him not having shisha on the premises smoked on those 2 dates. Obviously on the 26th I wasn't present, but PC Patel has stated that the shisha had been smoked on the premises. On the 25th I was present, and I can say that Mr. Hadju did everything possible to prevent, obviously, the police entering the premises by having the doors locked and then taking an exorbitant amount of time to answer the door. I believe that is so he could hide away the actual pipes that people had been smoking in the premises. Now, I said there was a smell of shisha in the premises, and it's been said this was because it had been carried through. What is my qualification to speak on that? I've been dealing with shisha lounges now for some 18 months and have been in numerous premises that are shisha lounges, pop-up shisha lounges, or places where shisha has been smoked. Because I have been in so many of these premises, I can tell when shisha is being smoked or has recently been smoked, against the fact that where there has been somebody passing through with shisha or shisha has been smoked some time ago. There is a difference between the pungency of the smell. Obviously, there was the evidence of the mouthpieces and the ash also on the floor in the public area. There were sales on the till showing the sale of shisha. And I obviously spoke to Mr. Hadju. Mr. Hadju initially said to me, no, he hadn't sold any shisha and no shisha had been smoked on his premises at all. That was what he initially said to me. When obviously the sales of shisha were found on the till, he then admitted, yes, he had sold shisha and people had smoked shisha outside the front of his premises. What I would say to you in relation to that was, if Mr. Hadju is allowing people to smoke immediately outside the door to his premises, he is treating that as his premises and as such is still covered by the coronavirus regulations. Because that makes no distinction as to indoor or outdoor, it's on the premises. He then later admitted, after the other things have been pointed out to him, the smell, the things on the floor, the sales on the till, that people had smoked inside. And his explanation was that there was heavy rainfall, which there was, I can attest to that. So people couldn't stay outside, so he'd allowed them to come in to smoke the shisha. That's what he said to me on that day. He didn't volunteer that initially to me at the outset. That was following a series of questions. I believe Mr. Hadju at the outset of that was telling lies. And obviously what he is saying now, that no people smoked the shisha on the premises, is also untrue. So that deals with those 2 points. Going on to my submissions, I would say there have been 4 breaches of the coronavirus regulations and the Smoking Act. That's been accompanied by 2 breaches of the operating conditions. Now, what could he have done with that, with the CCTV? It's an issue. The CCTV was broken. He could have got it repaired in a timely fashion. He said to me that it had been broken for a week. He had still got it repaired. He could have replaced the hard drive, got another hard drive and replaced the hard drive that he had with that one so that it then recorded. Or he could have not traded. So he had 3 options. His option that he chose was to just carry on regardless. Now, we've been told that there's 2 years where there's been no issues, that at the end that he has traded and promoted the licensing objectives. What I'd say to you in relation to that is, for part of that time, those premises would have been closed under the coronavirus regulations. There would have been no premises open. Also, those premises in that period of time weren't visited by the responsible authorities. So nobody would have known whether there were any issues around the trading in that period of time. What we do know is that more recently, when the premises have been visited, we have 5 visits. On 4 of those occasions, there have been found to be issues with the way that the premises were trading, either both breaches of the coronavirus regulations and the operating conditions. I would say that shows that 80% of those times when there have been actual visits, that there have been breaches, and therefore I would say there are routine breaches. Advice was given to the premises. Mr. Edwards, on his first visit to the premises, when shisha was smoked in those premises, gave advice. That advice was completely ignored. When he returned the following day, so again, people were smoking shisha. It's been said that that's because the message wasn't passed on. However, as a designated premises supervisor, as a premises licence holder, it must be ensured that when something occurs, that those issues are passed on so all the staff are aware. That must be done there and then. It's not a when it's wanted to be done, it should be done then. And that should have gone in the incident book so people could have seen it. I think Mr. Hadley probably summed this up when he said to PC Patel that despite the fines being issued, he needed to continue to trade, and that's what he did. He paid no attention to the dangers that he was putting the public to. He paid no attention to the licensing objectives that were in place that he needed to follow. His primary and only objective was profit. If Mr. Hadju can't be trusted to follow the coronavirus regulations and can't be trusted to have followed the licensing objectives, how can we trust him now in the future to follow the licensing objectives? As I've said, 80% of the time when the premises have been visited recently, there have been breaches found. I don't think you can trust the person that has carried out those breaches that they are now going to follow those licensing objectives. And therefore, I would ask that the licence be revoked and that the designated premises supervisor be removed. Thank you, councillors.
Thank you, Mr. Swallow. Finally, does the licence holder representative wish to make a closing submission?
Yes, please. So, again, just in closing, I started by saying to you that my submission was that revocation of the licence would be a disproportionate response. and I stand by that submission to you in closing as well. It is evidentially correct to say that these are premises that operated with no evidence brought before the committee of breach, no evidence of failure to promote the licensing objectives for a period of 2 years. And those that give evidence before you today make assumptions. You've heard assumptions that these are premises that were closed. And if they were closed, then of course they wouldn't be doing anything to either breach or not promote the licensing objectives. Far from it. These are premises that were able to remain open. They were able to modify what they were doing and provide takeaway and delivery of food. They were premises that were visited by the police during that time, colleagues of Mark Swallow, who were there to check just to make sure that there was no activity going on inside the premises when customers were not permitted on premises. And so they have demonstrated their ability to promote the licensing objectives. And it's just a wrong perception or a wrong assumption that's being brought to you by both environmental health and by police licensing in those particular terms. And so it is correct that they have been able to demonstrate that period of time. And equally, in terms of licensing enforcement, we're talking about matters which are old and dealt with, and again, this period of time in which they've been able to demonstrate compliance. So I fundamentally disagree that this is a blatant attempt by my client to persistently breach and to flout the regulations that are currently in force. My client has had his hands up. And since when do West Midlands Police become the experts on smoking and the smell of smoke? And certainly I haven't seen that or heard that anywhere before. My client's given an explanation for the presence and the smell in his premises on the 25th and 26th of June, but he's absolutely adamant in his instructions that there was no smoking and no breach of the COVID regulations going on the 25th and 26th of June. He has accepted, he puts his hands up in terms of what happened on the 4th and 5th of June. And he's not proud about that, but he's made sure that he's been compliant since. And that's demonstrated, as I've said to you, which isn't challenged, about the visit by EHO only last Friday. So these are all indicators of an ability to meet and promote the licensing objectives. And in terms of that, it remains for me to say that actually, I remain that revocation of the license, when we look at the activities that we're here to consider, is perhaps a disproportionate response. I'm not suggesting for one moment this should go without any admonishment or any measures. And what I've tried to do is take a sensible submission to you as a licensing committee to say, you have powers to suspend the license here for up to 3 months. And a suspension of the license, together with the condition that the premises license holder undertakes that updated training and delivers proof of the training to the licensing authority, is something that may allow you to exercise your discretion to give a license holder who has evidentially demonstrated some ability to comply that benefit of the doubt. And it's a little like that, the last chance saloon, or the sword of Damocles, whatever sort of phrase we want to put to it, but to give him an opportunity to demonstrate that ability to comply going forward. And that's what we seek of you as a licensing committee this afternoon.
Thank you, Mr. Thomas. I will now ask all parties to leave the Microsoft Teams meeting, and the members and the committee lawyer and the committee manager will go into private session while the subcommittee makes its decision. You'll be notified of the decision of the subcommittee before the end of statutory time limit. Thank you. Thank you for attending.
Thank you, Chair.
Thank you, Chair.